Embezzlement B. Under section 9, I think, which is offenses against property. We talked about larceny in A, now we're talking embezzlement. Embezzlement was not originally a common law crime intended to plug the gaps in the law of larceny. It was made a misdemeanor by statute in 1799 and is regarded as part of American common law. Modern statutes often distinguish between grand embezzlement, a felony, and petit embezzlement, a misdemeanor, based upon the value of the property embezzled. Although variously defined in different jurisdictions, embezzlement generally requires the fraudulent conversion of property of another by a person in lawful possession of that property. Distinguished from larceny. A. Manner of obtaining property. In embezzlement, the misappropriation of a property occurs while the defendant has lawful possession of it. In larceny, it occurs generally at the same time the defendant obtains wrongful possession of the property. Example: A was foreman of a construction crew. One day, he took a tool used by the crew to his home. The next day, he was fired. On his way out, he took another tool. Was he guilty of embezzlement of one, two, or no tools? Held. Only the first tool, which he converted while it was in his possession by virtue of his employment. He had no right to possession of the tools at the time he took the second. So, B is another being distinguished from larceny by the manner of misappropriation. B. Larceny requires caption and asportation with the intent to permanently deprive. Embezzlement requires intentional conversion. So, conversion. The conversion required by embezzlement requires only that the defendant steal with the property in a manner inconsistent with the trust arrangement pursuant to which he holds it. No movement or carrying away of the property is required. The conversion need not result in direct personal gain to the defendant. A trustee who siphons off trust money in order to donate to his favorite charity is as guilty of embezzlement as the trustee who uses the converted funds to pay his overdue gambling debts. Property. Embezzlement statutes are often worded in terms of property that may be subject to larceny. Real property and services may not be embezzled. Some relatively expansive statutes, however, make embezzlement of real property a crime. A. An agent with apparent authority to sell B's real estate fraudulently transfers a title to a bona fide purchaser. Is A guilty of embezzlement? No, under the traditional embezzlement statute, and yes, under the more expansive statute. 4. Requirement that property be that of another. Embezzlement requires that the property converted be that of someone other than the converter. Therefore, a person who borrows money, converts the sum to his own use, and subsequently fails to repay it is not guilty of embezzlement. Fraudulent intent. A defendant must intend to defraud for a conversion to become embezzlement. This appears to be the functional equivalent of larceny's specific intent to permanently deprive. Intent to restore. If the defendant intended to restore the exact property taken, it is not embezzlement, but if he intended to restore similar or substantially identical property, it is embezzlement, even if the money that was initially taken and other money of identical value that he intended to return. Claim of right. As in larceny, embezzlement is not committed if the conversion is pursuant to a claim of right to the property, as where it is retained for payment of a debt honestly believed to be owed. The fact that the defendant retained the property openly tends to establish a claim of right. Okay, page 68. Necessity for demand for return. If it is clear that there has been a conversion of the property, the victim need not make a demand that it be returned. If, however, there is doubt as to the existence of a conversion, a demand by the owner for return and a refusal to return by the defendant may be necessary. And limitation to property entrusted. Some states limit embezzlement to the fraudulent conversion of property entrusted or delivered to the embezzler. These statutes would not punish one who finds lost property and while in lawful possession of it fraudulently converts it. C. False pretenses. The offense of false pretenses was created by English statute in 1757 and consequently is part of the common law in those American statutes that use 1776 as the determining date. Like larceny and embezzlement, most jurisdictions distinguish grand false pretenses a felony from petite false pretenses a misdemeanor. The offense of false pretenses generally consists of obtaining title to the property of another by knowing, or in some states an intentional, false statement of past or existing fact, with the intent to defraud the other. Larceny by trick distinguished. False pretenses differs from larceny by trick in what is obtained. If only custody of the property is obtained by the defendant, the offense is larceny by trick. If title is obtained, the offense is false pretenses. What is obtained upon what the victim intended to convey to the defendant. What is obtained depends upon what the victim intended to convey to the defendant. D asks X if X would sell a car and offered a payment as payment what was purported to be demanded to be a demand note signed by Y. D falsely represented that the note was one executed by Y. In fact, D himself had forged it. X agreed to sell the car, but told D that the sale would not be final until she had collected the amount of the note from Y. X then permitted D to use the car until Y could be located. D drove off in the car. Has he committed larceny or false pretenses? Larceny, because X did not intend to transfer title to D. X intended only to transfer possession pending collection on the note. Now compare. Same facts as above, except the note purportedly signed by Y is due in 30 days rather than on demand. Based on Y's good credit, X agreed to convey full title to the car in exchange for the note. D drove off in the car. D has committed false pretenses rather than larceny. Now 2. Misrepresentation required. There are several limits upon the misrepresentations required for false pretenses. These also apply to larceny by trick. So a misrepresentation is required, but there are several limits upon the misrepresentations required for false pretenses. So A. False representation concerning matter of fact. The defendant must have created a false impression as to the manner of fact. If his statements reasonably construed constitute only an opinion or puffing, they are not representations. It is not misrepresentation to fail to correct what is known to be a mistaken belief that the victim holds, if the defendant was not responsible for creating that belief, or the defendant has no fiduciary duty to the aggrieved party. B. Misrepresentation of past or existing fact. Traditionally, the defendant's misrepresentation must have related to a past or present fact. And false promises to do something in the future, even without the present intent to perform, were not sufficient. However, under the Model Penal Code and the modern prevailing view, any false representation suffices for the crime of false pretenses, including a false promise to perform in the future. Now 3. Requirement that representation be the cause of obtaining property. The victim must actually be deceived by or act in reliance on the misrepresentation. And this must be a major factor or the sole cause of the victim passing title to the defendant. 4. State of mind required. The defendant must have known the statement to be false when he made it. However, most states will find that the defendant knew of the falsity of the statement when, after being put on notice of the high probability of the statement's falsity, he deliberately avoided learning the truth. On the other hand, if he believes the statement to be true, he has not committed false pretenses, even if his belief was unreasonable. The defendant also must have intended that the victim rely on the false misrepresentation. Subjecting the victim to a risk of loss will suffice for the intent to defraud. Example, A obtained money from B by representing that he was securing it by a first mortgage on certain property. He intended to pay back the loan. The mortgage actually given was, as A knew, only a second mortgage. Is A guilty of false pretenses? Held, yes. he knowingly subjected B to a substantially greater risk of loss of the money than B was aware of. This was a sufficient intent to defraud. 5. Related crimes. Many states have enacted specific legislation covering certain conduct that resembles the crime of false pretenses but is sufficiently different to warrant separate consideration. That is bad check legislation and abuse or misuse of credit card. Almost all jurisdictions have created a new and separate statutory crime prohibiting the giving of a no account or insufficient funds check with the intent to defraud. And B. Abuse or misuse of credit card. Most jurisdictions have enacted legislation making it a misdemeanor to knowingly obtain property by means of a stolen, forged, canceled, revoked, or otherwise unauthorized credit card. Okay, letter B is going to be robbery, and we're going to talk about robbery, a felony in all jurisdictions, a little bit later, but I guess for now, let's just define it as a taking of personal property of another from the other's person or presence by force or intimidation with the intent to permanently deprive him of it.